Um, have you noticed any other important or interesting developments caused by this pandemic, or which might impact in the future? So do we see already, for example, an increase in the number of cases being filed for mediation, either through court annexed mediation, Professor Ishida, or just in some of those ADR law certified organizations that offer mediation services, but typically each not in large numbers? Is it too early to see any increase in formal claims because everyone's still just trying to live out their everyday lives and you know, making lots of compromises and not asserting their rights even in a mediation setting? Or do we expect maybe a shift, maybe as things improve, hopefully next year with vaccinations and so on, and companies realize that the contracts they have had trouble with, you know, should be resolved through a more formal process such as mediation?
First of all, the number of filings, sorry to say, the number of bankruptcy cases is increasing now. But as to ordinary disputes, I don't know. I mean, I have to say that my guess is that it's decreasing because you may be surprised or not, but anyway, even today, Japanese court doesn't allow e-filings, or, you know, you have to physically file it. That's troublesome, especially under COVID-19 environment. So, but yes, it's true that because of COVID-19, the government's kind of promotion to government attitude to promote e-filings or e-proceedings is now accelerated. Yes, that's true. And also about ADR, now the government has a committee to discuss online dispute resolution, but still it's started to discuss. So it's very behind compared to other international circle. But yes, you are right that because of this situation, maybe they try to settle early and try to adapt ODR in early stage, maybe.
Potentially, if the court annexed conciliation process still is mainly paper-based and hasn't been able to become more online, even in this pandemic year, some of those other ADR law certified private organizations might attract more cases until the court system becomes more tech savvy and flexible. So that'll be interesting to follow into the future. James, I'll leave you with any last thoughts, if you have any, on this question of the impact on the pandemic.
I don't think I can add much to what Professor Ishida said, but I do think that mediation has a very important role to play, in particular online mediation, because of the pandemic, as firms and corporations are cash strapped as they want to maintain their relations with their contractual counterparties. It seems that mediation should have a lot of appeal in those circumstances, and the fact that it can be done online should facilitate the participation of new parties who are maybe geographically far from one another, and it's much easier and much more flexible to set up the mediations. So I feel like that would be, to my mind, a very natural way forward. The question is, will people actually take that route? I'm not sure.
I'd like to ask a more forward-looking question in a way, which is related to our global pandemic this year, 2020, and the impact that's obviously had on many areas of law, including court litigation, but also in particular, the international arbitration scene, where many arbitral institutions and practitioners have had to transition to having e-arbitrations, particularly virtual or remote hearings of witnesses, which lawyers had been reluctant to experiment with, even though this Zoom and other technology has been available for many years. So perhaps to conclude, I'll ask each of you to give us some perspective on how practice in Japan has evolved to cope with the pandemic, and in particular whether you think it's likely to continue into the future and actually give countries like Japan and even Australia, which is more geographically remote, more of a comparative advantage to become a popular venue for international arbitrations and more generally a credible regional hub for international dispute resolution services. So Professor Nakamura, please.
Oh, yes. Yes, I think, as I mentioned at the beginning, I think now the arbitration is being conducted remotely with use of internet, and so due to the pandemic. And so I think for the time being, this type can be continued. But after the pandemic is ended, I think our practice will use remote hearings or online hearings, and because they are very convenient. And Professor Notis mentioned that venue is used to be very important, but online arbitration venue is not so important. We can do that remotely, and we can save the cost for the traveling, for instance. So I think after the pandemic is ended, that the remote hearings can be proceeded, not all, but for some parts of the arbitration proceedings. And so I think arbitration style will be changed even after the pandemic is finished. And lastly, I think, as I mentioned in the beginning, for the developments of international arbitration, in particular by the financial support of the Japanese government. So I think this is just first time forever in Japanese history. And so I'd like to see how the international arbitration in Japan is going on. And I think it's very important period for the next couple of years, whether Japan can become one of the international arbitration centers or not. So I think it's the most important, and combined with the corona pandemic. So Japanese arbitration should struggle for the enhancement of international operations as much as possible. That's all.
Thank you. And Professor Colombo.
Yes, I agree with everything Professor Nakamura has said. Even though e-arbitration was pushed to this very rapid development by exceptional circumstances, and we all hope that those exceptional circumstances will be over quite soon, I think the use of technology in arbitration is here to stay. And that would, I think there is a chance that could help countries which are geographically remote to play a stronger role in the international arbitration community. Now, there are a lot of concerns now about cybersecurity and the procedural issues. And of course, they are legitimate concerns. But my impression is that a good part of these concerns are actually slightly overblown by some part of the arbitral community somehow resisting change and not wanting to give up the fancy 1 week hearing in a nice hotel on the lakeside. So there are indeed concerns, but I think the period of history is adequate to deal with these technical and procedural issues. So let's make good use of what this crash course in use of technology in arbitration has taught us during these months and try to implement that for more efficient and more cost-wise arbitration proceedings.
Thank you. And Dr. Teramura, you have the last word, if you'd like to add something.
Well, my point is, of course, the use of modern technology could be useful for Japan and Australia to overcome geographical remoteness. However, I'm not always optimistic about this because by that is meant both Japan and Australia might be exposed to more intense competition brought about by the remote hearings. So if, let's say, we have two parties, one in Japan, one in China, they have a dispute. Well, these days the norm is they bring their case to Singapore. However, the Japanese party might complain Singapore is under the strong influence of China. Then where should they go? Maybe they can go to London, but they don't have to go to London physically because they have virtual hearings. So then will they bring a new case to Australia? Maybe not. So this is my concern. So the point is both Australia and Japan have to work hard to catch up and prevail in the next intense competition. And the competition has already started.
Could I ask you whether you've found any really important, interesting developments in your fields, either of practice or substantive law, due to this COVID pandemic, which has forced us to take these measures, like trying to hook up to interview you remotely rather than taking the students to Kyoto seminar and then visiting you in Osaka along with the courts? And do you think some of those developments will persist beyond this pandemic? So even hopefully when we get a vaccine or cure or manage it in the future, do you think some of those things will have a long-lasting impact? So Jerry, do you want to kick off, please?
So yeah, I mean, I think the first thing that immediately comes to mind in response to your question is the communications technology that we have today. I am, amazed. Don't get me wrong. It's inconvenient sometimes not to be able to travel abroad or see your clients, or to be able to meet face to face or go to events. But at the same time, given the dire circumstances and nature of the pandemic, it's amazing to me that our firms, because of the technology, have been able to continue and provide service to our clients. I mean, we adjust our schedules and try to reduce the amount of time in the office, but our firm is very busy, and I think it's really because of the Zoom and a lot of the other technologies that exist today that allow us to keep communicating and continue to work. So if this had happened 10, 15 years ago, I think we could have been in a very, very, much worse situation. So the technology is one thing. The other, there are certain areas, and I think the technological aspect is going to teach us something and will continue beyond the pandemic, because it does provide a lot of efficiencies in many ways. As far as areas, I think that, if you're in a full service law firm, you kind of have the ups and downs of economies and societies and times. So, when one area is up, the other is down. So M&A might be down, but now, employment, issues are up. So you as an attorney, you just kind of have to, ride the wave and, be prepared as an attorney and as a firm to deal with the various, different legal issues which the times throw at you.
Thank you. Obayashi Sensei, dozo. You get the last word.
Okay, so actually, to be honest, the Japanese court procedures are very old-fashioned, I would say. And the courts doesn't accept the emails, and only they accept the faxes. We are required to go to the every court hearings physically, but due to or thanks to the COVID-19 pandemic, now the courts are using the team for having the court hearing, so we can communicate with the judges online right now. So that is a good impact on the court procedures. And then I hope that the Japanese court procedure would be more and more sophisticated. Then we should use such a ID measures
was last November, I had a report in the Japanese Society of Computer Technology and Law for the using information technology in the criminal justice system. So I just contribute my short article to Hogak Seminar, the one of famous commercial magazine in Japan. So I took a survey of using information technology in the foreign countries for pandemic era. So unfortunately, the average using technology in Japan is behind the other countries. So I learned a lot from other countries for using technology in the various process of criminal justice. For example, in UK, they started to remote legal advice to interrogation room to the suspect. It means attorney can access to interrogation room from their office through a telephone or video conference. So it's one of a solution for avoiding infection of COVID-19. And other challenge from US is using electronic monitoring, the GPS technology. So for a condition of a bail from prison. So as you said, prison is very dangerous for infections of COVID-19. So for example, in Illinois state, they decided to set the electronic monitoring to all bailed persons last year. So it is one of the technological solution of a bail reform in the pandemic era. And the pre-trial stage, the many countries introduced a remote hearing. In Texas state, Zoom jury selection and Zoom jury trial. So it is very challenging trial. So, but they started that. So on the other hand, in Japan, the court office is very afraid to introduce such a remote technology, online communication to their practice. So only in civil procedure, last year they started to introduce pre-trial or hearing among lawyers and judges. But they never used in the criminal trial process. So it's a very reluctant. I think this year or next year, Japanese court will try these technologies. But now it's late. Yeah, I understand the remote trial has a big problems, especially in the view of constitutional law. For example, the fact-finding process, hearing the testimony from a witness and looking the real evidence and check and reading a lot of document. So there is very critical issues, but for avoiding the infection of COVID-19, we have to use such technology as a kind of solution.
the influence from the COVID-19, not so quite, I suppose. Of course, you know, such a remote hearing or conference is used more for the party living far away from courthouse, but still we need to some change of rules because you know, anyway, it's still lawyers should go to the court anyway. So party can be, you know, stay at home, but so not so much differences because of the COVID-19.
Finally, 2020, of course, has been the year of COVID-19. The whole world has been affected by this pandemic. In Japan, of course, during the pandemic, officials have also, this has certainly been the case in Australia, have exercised greater control, issuing public health directives. We can see that in the United States, for example, there's been strong political resistance to some of those directions, especially with wearing masks. In Australia, largely, there's been a little bit of resistance, but largely there's been compliance and acceptance. In Japan, how have the roles of local or state authorities changed in response to this health crisis? And do you imagine any new developments in administrative law or administrative review that might arise from this 2020 pandemic?
Okay, Japan has coped with the COVID-19 with the law about the swine flu, which has been enacted in 2012. First, actually, that the law cannot be automatically applied to COVID-19, so the Japanese government changed the law in order to apply the swine flu, the law to the COVID-19. And first, it gives the government the powers to, well, declare the situation of emergency in the area. But the interesting point of this emergency declaration is that even with this declaration, the rule of law does not change at all. That any kind of measures which were taken by based on the law is just a legal measure, not so to say extra legal measures, but which can be imagined by the term the state of emergency. And secondly, the one of the features of the Japanese government response is that it uses, well, administrative guidance. Again, for that, of course, it may contradict the theory which has just developed now. That we can observe that administrative guidance is still a very powerful tool to guide people's purpose. Well, for Japanese government recommends people to wear masks, and this wearing mask is a very without any punishment or without the legal enforcement. It has been very well observed in the Japanese social, social space. And another issue related to COVID-19 is second issue related to COVID-19 is that the usage of public disclosure of the non-compliance. In many cases, Japanese, especially local government, has often used the tool of public disclosure of non-compliance in the field of, again, for the administrative guidance. And in the field of this COVID-19, and this tool is used also by the national government. For example, based on the national government law, but used by the local municipal, local prefecture governors. Namely that once there has been, I'm not sure whether the audience of the year know about the pachinko, but the pachinko parlor is one of the, so to say, pseudo gambling place for them. And of course, this on pachinko parlor, there are people have gathered more, so there is a danger of COVID-19 infection in these areas. So one governor had recommended based on those swine flu law, that the governor recommended the pachinko parlor will shut down for a while in May, but the pachinko parlor didn't follow. And the law allows in such cases to disclose the name of the non-compliant pachinko parlor in that. And such kind of usage of social informal tool was discussed in the public communities, the public opinion. Some people say this is against the rule of law, but that is the tool which is prescribed in the survival law itself. So that such kind of usage has been often prevalent, but because of because of the outbreak of the COVID-19, this has again attracted the people's attention. And the second issue is compensation for the closed facilities in such cases, but I would say this is a very common problem in many countries.
Sort of conclude this interview with what's happening today in the world, which of course is the COVID-19 pandemic. Now, there have been many legal or regulatory issues. You've mentioned, for example, that the government, as part of keeping the economy going, has given out sort of some payments, but it's been directed to the head of the household. So that has gendered implications. Are there any other issues in the gender space that are arising because of COVID-19 or that might emerge in the future?
Well, I think one is, I think it's kind of worldwide issue, but DB problem became serious. Because, you know, many people just stay home and there is no escape place for the victim of DB, especially women. And also another issue is very serious economic status of single mothers, because their working status is already before COVID-19 very, you know, unstable. And because economy go down, then many of them just fired. So I heard that by the end of this month, I mean December, the government will distribute another additional money for single mothers. But yeah, I think it's a very serious problem.
So has the pandemic affected more so women workers? I know, for example, in Australia, the main industries that have been affected have been hospitality and the industries. And there is research to show that it's typically been female-dominated professions that have been hurt by COVID-19. And many of the government's sort of targeted industry support have focused on supporting traditionally male-dominated industry. So that's a gender discussion that's taking place here in Australia. What about the economic impact of COVID-19 on Japan? Has it affected men and women equally, or has there been a disproportionate burden borne by women?
Okay, because it's impacted on so-called hiseiki koyosha. It's kind of what's the
regular work? Yeah, contract workers or irregular workers.
Irregular work, yeah, and the majority of them are female, and that was why it's more impact on female workers.
Actually, the first point is that the government has been very reluctant in producing gender statistics. So it has been very difficult for many people who are concerned to find out the real effect the COVID-19 had on women. We know that temporary workers are laid off. And we know that the majority of that are women. But without all these statistics, we don't really know what was the real impact within the society. We do hear and we do realize lots of sort of anecdotal information that was happening, or that not just that they were sort of sacked. Some people, for example, refrained from going because, for example, they had elderly people within the family, and therefore they don't want to expose themselves to the
virus and go back home. And therefore they ask for a leave, a very long leave. Eventually they're fired, I hear. But that kind of things doesn't sort of occur to the man's mind in Japan, apparently, even if they are in a similarly situated. Some of the statistics, the researchers had revealed that a lot of people were working from home, men and women. Nevertheless, women apparently are doing about 5 times as much of the family work within that same situation as men, according to some of the researches done by a professor in Kyoto University, for example. And I think that's a small sample, and that having both people within the family to do sort of at-home working situation means that they are in a very well situated company, very well paid, able to provide all these sort of computers and such for individual people. That means that they're really well off within the Japanese society.
I just end by asking each of you, particularly Professor Yoshimasa, who's written an interesting paper on this recently in a symposium comparing developments in Japan compared to Germany in the COVID pandemic era. What have been the interesting responses and likely further developments in contract law in Japan arising from the COVID-19 pandemic?
So Professor Note had also joined the conference online, and he had kindly referred to my presentation on the effect of COVID-19 on Japanese contract law. And in that presentation, I argued that the Japanese contract law seemed to be more flexible compared to German contract law, and the Japanese lawyers, Japanese jurists tend to react to the pandemic by applying the existing legal doctrines more flexibly. On the other hand, German legislators have adopted many important legislations in the field of contract law. One being so-called moratorium, the postponement of the due date of the payment. But Japanese legislators never seriously considered adopting such drastic measures to react to the pandemic. And Japanese lawyers tend to react by applying the existing legal doctrines. For example, by applying the article on damages, and the damage, more specifically, it is Article 415 of Japanese Civil Code, providing that the damages may be exempted when the non-performance is caused by the reasons which are not attributable to the debtor. And by applying the article flexibly, maybe courts will allow the exemption of the parties in some cases. And there are more other doctrines which are based, as Professor Taylor has mentioned, which is based on doctrine of good faith and other more flexible legal grounds. And by applying those doctrines and flexible rules, Japanese courts are able to react to the pandemic. So the reaction of both civil law countries and Japanese contract law having its base on German contract laws, they both, so at first sight, you might expect them to react in the same way, but in reality, their reaction was pretty different. One being more one, namely Japanese law, reacting to the pandemic by applying the existing rules more flexibly. And on the other hand, the German law, German legislators drafted the new legal rules and to react to the pandemic. So the reactions were pretty much different, and that reaction, the difference seemed very interesting to me as a legal professor. And that was what I had presented in the conference that Professor Nottage had mentioned.
Thank you. Yes, that is interesting that despite a lot of common background and mutual understanding between Japan, particularly Germany, in relation to private laws, especially contract law, there is this difference. It could be partly explained perhaps by the fact that the pandemic hit Germany a lot harder in terms of infections and impact on the economy, and particularly death rates in Germany compared to Japan. But as you say, even when it was unclear whether the pandemic would also severely impact Japan, as in Germany and some other European countries even more so, the policymakers were not so seriously thinking we need to enact particular legislation for this, because they were expecting that even the old civil code provisions on contract law, even before the reforms here, would be enough to do the job, perhaps given you know, the contract practices and expectations, particularly of smaller, medium-sized enterprises, as to what to do when a problem arises, including something unexpected, or perhaps particularly when it was an unexpected, unattributable cause like the pandemic. Now, the last question I want to ask before we end is whether you have noticed any significant impact from the COVID-19 pandemic in terms of consumer issues that have arisen and have, you know, caused a lot of discussion, maybe even some particular law reforms or regulatory action taken because they've caused a lot of problems in the consumer marketplace.
Well, no, actually, to make it short, no, I'm not aware of any such big issues. Of course, it's not yet, I mean, we're just in the middle of the pandemic. Maybe something will turn up shortly, I don't know. But as you know, I mean, the approach to regulate pandemic-related issues, I mean, with regard to business as well as regard to, well, consumer-related matters, was very, I say, mild. Yeah, it was more suggestion what you should do or what you shouldn't do, and nobody was really forced to shut down its business. So if you're not forced to shut down the business, then it's on your own to decide whether you do it or not, and then you cannot bring any claim in this regard. I mean, I was in Melbourne last year, so I have many contacts with people living in Melbourne, for instance. It was a totally different situation when the pandemic started. I mean, the regulation was very, very strict. And here in Japan, I returned in March, came here and was looking around. Well, there's a pandemic going around, but I mean, the shops are closing a little bit earlier than usual, but apart from that, you wear your mask, and there are no further really restrictive measures in place.
That's very interesting, because in Australia, we've had quite a lot of complaints and follow-up through consumer organizations and consumer regulators, for example, over the refunds for cancellation of travel. Initially, airlines and travel companies were not giving refunds. They would at most give a voucher for future purchases and so on, sometimes relying on terms in the contract agreed to by consumers, but typically never read, like most consumer contracts. But the regulators and so on raised the possibility of those being an unfair term, and therefore, you know, a reversion to the general law of contract, which allows for contracts to be terminated for frustration if, you know, you don't get the service or you can't travel because of an unexpected supervening event like a global pandemic. So it took actually many months and quite a lot, and still these sorts of disputes are ongoing, or at least taking a long time to resolve, whereas I don't see so much evidence of that in Japan and so on, which indicates that partly because maybe more travel happened, but certainly the international travel was restricted. So I assume that instead it's because Japanese companies, you know, want to really take care of their customers and so on. And if someone asks for a refund, they're just being refunded actual cash or yen. And also, you helped organize and present at a conference comparing the pandemic response more generally in Japan and Germany. And of course, in Germany, one of the presenters was explaining there's been quite specific legislation enacted dealing with, you know, the more common types of disputes, for example, over tenancies, leases.
Yes.
Whereas in Japan, it's been left to the background law, and the government seems to assume that, you know, in that sector, maybe with a little bit of encouragement by the regulators and so on, that the businesses will do the right thing and be reasonable, and therefore they won't need to regulate. So that struck me as an interesting comparative difference here between the two.
Finally, you mentioned masks. So we have to recognize 2020 is the year of COVID-19. This has meant for us that the Kyoto and Tokyo seminars cannot be run in early 2021 because of the ongoing uncertainty. COVID-19, what impact has it had in terms of corporate governance? Have there been any issues that have arisen, or do you see any future issues arising in 2021 following the pandemic? Or has there been no influence whatsoever? What's the relationship between corporate governance and COVID-19?
Well, one very direct impact took place with regard to shareholders' general assembly. So Japanese companies, and most of them hold shareholders' assembly in late June. And late June was still just after 1 month of the end of the declaration of emergency and by the Japanese government. So emergency was declared in early April and ended in late May. So when it ended, there was only 1 month left before a general shareholders assembly. So this year, kind of without a solid statutory basis, and a government and also private lawyers took the view that the shareholders meeting could take place virtually without a getting together physically, and under the current statutory scheme. And it was a decision, at least under the emergency situation. But now, and people are starting to discuss, why not give this a permanent and a status? So why do we get together physically every year? Is it really necessary? If the important thing is communication with the investors plus voting on important issues, why can't these be done virtually through the network? And of course, in a more broader sense, and the risk management has been accepted as a big issue to corporate management. And it was not only COVID-19. So in 2019, for example, we had a few very big typhoons hitting the urban area, including Tokyo. So universities were closed on that day, and or on the day before, I would say, and many shops also chose to close early. So it was again it again gave the corporate management and a occasion opportunity to think about the risk management, and still the memory of East Japan earthquake in 2011 is quite vivid among many people, many Japanese people. So given all this, and with the COVID-19 pandemic in 2020, and now the corporate management has to really take this issue of risk management and contingency seriously, which will be a big corporate governance issue in the coming years.
So 2020, of course, has been the year of COVID-19, and that's caused major disruption around the world, in particularly economically. So what type of impact has the pandemic had on employment practices in Japan? And do you see any future issues arising from this 2020 year?
Yes, COVID-19 had a huge impact on Japanese employment practice. You know, under the long-term employment, Japanese corporation preferred teamwork. So under our practice, Japanese employer hires not for the specific job, but when they conclude an employment contract, there's no job description. They agree to work for that corporation as a member of the corporation. There's no job description. So teamwork means there's no specific work what a particular person should do. So they always discuss together and what should be done. So such kind of teamwork is a normal way of work in Japanese corporation. But COVID-19 compelled each worker to stay home and conduct remote work, which means that work must be done individually as in a separate situation. So Japanese corporation and also Japanese employees are not accustomed to such kind of way of work. So in the last several months, many people, many commentators contend that Japanese society should introduce the foreign-style job-specific employment. So telework or remote work will work efficiently. Otherwise, it's traditional way of work. It doesn't fit to this kind of telework or remote work situation. So this COVID-19 had a huge impact to the change of our traditional way of work. But this kind of telework or remote work has a very good aspect for the people who have to balance life and also work-life balance. In the Japanese traditional way of work is very hostile to the work-life balance. But new way of work is more easy for them who bear the family burden or child care responsibilities.
To say, maintain the balance between the economic activities as well as the prevention of the pandemic. And so Japanese people are quite confident that our government would not move into a quite strong lockdown policy like UK, Germany, or New Zealand in the past. So in that context, the Japanese economy would not be so terribly hit by this pandemic this time, but we have been damaged by the pandemic in the past half a year, and the problem caused by such as a pandemic will cause some difficult situation of Japanese industries located in regional areas in Inaka, and they will lose their business, or they will close down voluntarily because time is not good. And what would happen is that the regional banking institutions, such as so-called Chiho Ginko, regional banks, and other regional, say, lending association, will have to close down their business. From the viewpoint of competition, it's a right decision. But the problem is that how to maintain the service, financial services to the people living there. Nowadays, younger people can do financial transactions using computers. But Asian people like me, we have difficulties in handling computers or smartphones. And automatic teller machine are quite widely located in our country, but Asian people have difficulties in using such machines, which means that the bank will close down their branch offices and put ATMs. But at some stage, they will also close down such ATMs, and those people, especially Asian people in such regional area, will have no access to the financial services. This is what the Japanese Financial Services Agency should focus to. And they are fully aware of this problem. But I think this is one of the negative result of the pandemic. Everybody expected that such thing would happen someday in the future, but the pandemic puts everything take place quite speedily. So this is a very difficult situation caused by pandemic.
In addition to the effects that COVID might be having on kind of our policy around environmental taxes, just more generally in the international tax law area, do you have any kind of editorialization about what's going on in the near to midterm future here?
It's a good question, Micah. A year ago, there was a definite trend towards convergence of tax systems around the world. In other words, there was an attempt to create almost like an international tax order, and every country would have a similar tax system, which was primarily designed to create a level playing field and to prevent opportunities for tax avoidance. But in the last year, there's been this sort of massive push back against globalization, partly because of Trump's America, I guess, partly because of the troubles Australia's had with China, and a sort of perception that we need to encourage our own domestic enterprises and not be so reliant on overseas imports. And also partly because of this sort of fear of foreigners that's sort of prevailed because of COVID. So there seems to be this pushback. And so I foresee, and I think a few other people are sort of promoting this idea too, that we may see our tax systems begin to diverge again and become different to each other, particularly in the focus on encouraging domestic enterprise at the cost of foreign enterprise. So I think we might see, for example, tax breaks, which would encourage domestic business. At the same time, some sort of barriers are placed on foreign businesses operating within our shores. So I think that's a distinct possibility.
It would be an interesting development in how we teach this particular course as well, because I don't mean to speak for you, but I think in previous years we've spoken, and you introduced the course partially in this way. We've spoken about how there are these areas of overlap, and the course kind of focuses on some of the basics of international law, with a focus on kind of what might be somewhat specific to Australia and Japan. But our general tenor of that has been, Japan can illustrate some of these general ideas floating around in international tax law, but tax law isn't is not one of the areas where we rely heavily on talking about kind of cultural determination and things like that. Japan, isn't particularly Japanese when it comes to just talking about tax law.
Yeah.
But this might provide an opportunity, because every country will, should they start to engage in tax law-based protectionism, they'll do it in their own particular way. So that would be quite an interesting way in which the way we teach the course could change as well.
No doubt about tax law. It really is interesting, isn't it, Micah?
Always, always.
One of the joys of being a sports law researcher is that these things evolve, so you have to wait to see how they play out before you make too many comments. But I suppose what is going on with the Tokyo Olympics is going on in baseball, and it ties into my PhD in that one of the key things I looked at, and I should point out that my PhD and book was on the labour regulation and labour mobility in Major League Baseball, Nippon Professional Baseball and Australian Baseball League, is basically that you've got, foreign players. And so, when the coronavirus started last year, I tweeted about, how's everyone going to get into America from all these countries all around the world? And so I think that, globalization and labour mobility in a sport like baseball is interesting from a regulatory perspective, to see that a sport like Major League Baseball now embraces people that can play baseball from any country in the world. Keeping in mind that it wasn't that long ago that Jackie Robinson broke the segregation of Major League Baseball and really sport in America. And in a very short period, it's gradually globalized. It was first with Latin players, and then Hideo Nomo broke open for Asian players, and then Australian players, and other people have sort of been dispersed through that, as opposed to, say, a country like Japan and the NPB, where you've got a limitation on foreign players per team until you become a free agent in Japanese baseball. Then you're not counted as a foreign player. And then in the Australian Baseball League, in its second incarnation since 2010, has gradually decreased the requirement for Australian players and the level of protectionism for Australian players, to the point now under its current ownership structure where there's really no requirement for Australian players. And so I think that's this is an important thing, because there aren't many sports that don't have a globalised labour supply. Even sports like the Australian Football League have foreign players, both the men's and women's league, and Irish players. And the movement of players and people is now, it's heavily restricted. And so from a labour point of view, like I know with the Australian Baseball League this season, what happened, when players can't get a visa to go and play for the Canberra Cavalry has happened. They didn't have enough players for a team in the round one. Where do you get the players from to maintain a professional level? The professional levels here. So I think that's I think risk management is what it comes down to, Micah, is that, like the way administrators and clubs and player associations look at risk management and what it is and how to manage it is really different now, because you have to have contingencies in place. And I think the other point that I would just make on the coronavirus and professional sport, and in Japan, I don't think it's been as big a problem, but in most other sporting leagues, at least in Major League Baseball in the US and Australian sporting codes, players have had to take big pay cuts. And there's issues of equity. The top paid player versus the lowest paid player. And in terms of just one other point on Japanese sport, the big issue at the minute, which I know Professor Keiji Kawai has been advocating against in Japan and working with the government, is the introduction of the US collegiate model to Japan. So that's a significant issue, I think.